Hey, hello, how are you? I hope you're doing well. My name is Adrian, and today we are going to present to you the video number 3 of Conservatorship. Okay, so this is a video where you are going to learn about the last part of the process of conservatorship. As you know, if you have not seen the other videos, we highly recommend that you do, because in order to understand this one, you need to have watched the other 2 videos. So this is video 3 of 3. So, important disclaimer, this information is not a legal advice. We pretend to guide you through your legal process so you have an informed opinion. And of course, you can go through the process and have already informed questions as well. So, this is presented by Navigating Change program of San Diego State University and in the Social Policy Institute. So, what is the purpose of this section? We would like to provide step-by-step explanation of the conservatorship application process. And we want to help families understand the required documents and clarify how the notification process works. And we also want to explain what to expect after filing that petition. So let's have a quick review. Just to remember that we understand that this is not an easy process, but a conservatorship is a legal process that protects an adult who cannot safely make decisions on their own. And there are different decisions regarding health, education, services, safety, finances, if applicable, and file the court of the country where your loved one lives. That's very important. So in other videos, we explain each of these. If you want to remember, go back to those videos. So the types of conservatorship, remember, you can have a conservatorship of the person. So this is for his personal, medical, and well-being decisions, or also of the state, in case that your loved one has income or important assets. And these can be general and limited, and that would depend on the level of support that you needs. Remember that the judicial system main concern is the well-being of your loved one. They will decide if your loved one needs limited or general conservatorship. Okay, so that's just a review. Now let's go talk about the key documents. There are several options for completing the documents. First, we highly recommend to go to legal aid, and they will help you complete the forms. Or you may hire a lawyer to complete them with you. Or also maybe you want to complete the forms yourself and go through independent advisory if that is to check it for you. So those are the 3 options. But please don't do it on your own. It can be very overwhelming. So get help. So these are the main documents that need to be completed. In the previous videos, we explained each of them. So we want to emphasize that once you go to legal aid, they will provide information, and also they will fill out the forms for you. Okay, you give them the information, and they can fill them out. You may also download them on PDF, but I've been told that legal aid sometimes prefers to do them themselves because they need to check less. So that's up to you, of course. So what is the medical capacity declaration? This is one of the most important or key document, let's say, that it needs to be done by a licensed medical professional. And it evaluates the ability to make decisions, They evaluate the memory, the reasoning. They also evaluate understanding of medical information, the need to support with daily activities. And this document helps the judge understand the loved one needs. So a recommendation is that legal aid will help you pre-fill with the general information. What is the general information? Well, the name, the case, the address, just the basic. And then you ask your doctor. It is important that you inform your doctor in case that he asks or she asks that they do not need to go to court. They are only to complete the forms, but they will not be required to go to court. Sometimes they're afraid if they have to go testify, that is not needed. Now, please let us keep in mind that our medical providers are very busy, and maybe you can ask them if it'd be a good idea to make an appointment with them and you have the information pre-filled and that they can fill it out for you. And maybe they can ask with you, and as they're completed, maybe they can ask you questions. But of course, they must fill it out. Do not fill out for them. It contains very important medical terminology that only the doctors will know. So, also, you need to file for a fee waiver. And this fee waiver is available when the loved one has no income or asset. It allows families to file without paying court fees, and the court reviews and approves the waiver. Usually, if the person to be conserved has medical, the waiver is usually granted. The cost of the process can vary from what I'm told, and according to our research, it can be from $400 to $800, depending on the case. So if you have an opportunity to waive that, if your loved one has medical, it's a good idea to have a fee waiver. So what to do once you have to file in court? Well, you are going to bring your documents again. This is a recommendation to your choice. But if you go to legal aid, which is in the same building, you go to legal aid, and then they can ensure that your package is complete and that you have everything that is needed. And then once they have organized your package the way the probate office needs it, they will ask you to make a copy. Recommendation: bring cash, because you will need to make a copy of the complete set, and it's about 25 cents a copy. You can go to the nearby library, and if you don't have cash, I think they do accept card, but you will have to buy a card for the copy machine, and then like I said, it's 25 cents a copy. So that's something to consider. So once you have filed the probate, you are going to take it to the Superior Court's Probate Division, which is also in the same building, different floor from Legal Aid Society. In San Diego County, it is downtown, the courthouse. Remember that depending on the county that you're in, is where you need to file. If you're listening to this video and you're not in San Diego County, then you need to go to your own county. So at filing families, you will receive the case number, and then the hearing date, and the official notice of hearing form. This official notice of hearing form is very important. What does it mean? It means you must notify first the family members, and you also need to notify the person that is going to be concerned. Let's talk about the family members first. Well, California law requires notifying certain relatives, like the parents, the grandparents, the siblings. And this is very important. All you have to do is prove that you have sent the notification. Say that, for example, sometimes families are not together, and sometimes the parents are no longer in good terms. So it's okay. You don't have to. All you have to do is prove that you have sent it. Say that you said, but I haven't seen them for a long time. Well, that's okay. Just send it to your last known address, all right? And then you just have to send the proof of sending. What is the proof of sending? Well, this is important. The proof of service is that you must be completed by someone else. You cannot complete it. You cannot do it yourself. Someone else over 18 must, that is not the petitioner, must sign this form. And it's going to include the address where the notice was mailed, the date of mailing, and the signature of that person who mailed it. So these forms must be filed in the court before the hearing. So once you have the forms, you need to have that. Now, something very important, just as you have to notify the family members, you must also notify your loved one, the person who is about to become the conservatee, and they need to sign that they agree. It's up to you how you want to manage that, but in depends on everybody's case. I know some people did not notify them, and then they go to court and they don't know exactly what is happening. And in that moment, if they say, no, I don't want to be conserved, then they won't be conserved, and it can create a problem. So what I have done is depending on the case, like I said, but I asked one of my son's teacher. So I explained to my son what I needed to do on his own terms, his language level. And then I took the form. His teacher told him in the same terms that I had already explained to my son. And they pretty much, because they trust him, so I was able to have him sign that form. So it really is up to you, but just make sure that someone that you trust and that the person that your loved one trusts is the one notifying them. So also very important, you must send a notification to the San Diego Regional Center. So once you receive the form, you send a notification to San Diego Regional Center. And then that letter, you must send it as soon as possible. Why? Because please remember, our service coordinators are also very busy. They have a very important caseloads, and we need to give them ample time for them to complete the forms, because it is required that they complete the formats that they have given. It is that you send it to the office, and it is very important that you tell your coordinator, call them, send them an email, and preferably as an email, and tell them that you have sent that notification. So once you send that notification, you tell them, because it's going to go to the general office, and you just put in care of the name of your coordinator. But in order for them to know that this email, that this important mail is arriving, they can be on the lookout. So if, again, please tell the date of the hearing so they can complete it at least 3 weeks before the hearing date. So you notify your service coordinator, please, and tell them when your hearing court is going to be. For this is such an important document. We have the assessment capacity, but if we don't have the service coordinator form, then you may need to reschedule your hearing date. So that's why it is very important. So give him ample time to complete that. Now, once you have filed your documents and everything is there is going to be an investigator appointed by the court. And they will contact the family, and they may conduct a phone interview or a home visit. So what are they going to evaluate? Well, usually they check about the loved one needs, they're safe, the kind of current support that they have, and if the conservator is suitable for that person. So it is just a routine. So then the investigator provides a report to the judge. So be prepared for that one. Let's make sure your house is clean. Now, just be on the lookout for that. So you need to review the probate notes. Okay, what are the probate notes? Well, on the web page, they are usually posted approximately 3 weeks before the court hearing. So you need to be in the lookout, going to the web page. They will tell you the page once you go to the probate office and giving the document. And we strongly recommend that you review them before the hearing date. As we said, at least they are going to be posted 3 weeks in advance. So be in the lookout. So what can you find? Well, you need to see maybe there are special recommendations from the court, or they may be requesting for additional information or documents. They may be required some corrections in case that there's some mistakes on the forms, and they may be missing information that must be submitted before the hearing date. So once you review the probate notes in advance, gives you the opportunity to address any outstanding issues and arrive on the hearing date better prepared. Tip: don't wait until the day of the hearing. We need to emphasize this enough. Please check the probate notes as soon as they become available, and then that will help you avoid rescheduling your case. So what to expect on the hearing date? Well, the petitioner, that means the person that wants to be the conservator, must attend. Sometimes they give you options, whether it can be in person or online, but from what I hear, it's always better to do it in person. And your loved one may be excused if the doctor indicates that they cannot attend. Of course, please remember to let your loved one know what is happening. It's very important. And then what is the judge going to review? Well, they're going to review all the documentation that you turn in, the investigator's report, and the loved one's needs. Remember, we have the assessment capacity and the report from the San Diego Regional Center. And of course, once it is approved, the judge will grant the conservatorship. So once it has been approved, after the hearing, the families will receive a letter of conservatorship. But the family is the person appointed to be the conservator. Remember, you don't need to have only one. You can have as many as 3. They can be co-conservators. So that is a very important possibility. And then it is mandatory for the conservator to take a training that it must be completed as soon as possible. And then you will ask to have a general plan that needs to be filed within 90 days. The recommendation here is to talk to your regional center coordinator, and your service coordinator has an IPP already. So the individual personal planning, IPP, sorry. I was getting confused with the IEP, individual education plan, that's for school, but the IPP is the one that the regional center has, and that's the individualized planning program for your loved one. So make sure you talk to them, and you can, that way it is paired, and the goals are similar. So then you need to have ongoing reports that may be required, and that will be depending on the case. So these are the most important forms. We're giving you this little slide for you to pause. And remember that these documents may be needed or not, because it depends on the conservatorship type that you're asking. If it's limited, you need some forms. If it's general, you will need others. But we have decided to add this here because this way you have the name of the forms and what number they used, in case that you need to look them up and download them on PDF. Like if you want to download the capacity assessment to help you pre-fill for your doctor, that is a good idea. So again, this is for you to have remember that you can also download a handbook that is available for you to read all of this. In these 3 videos, we have tried to condense all the handbook for you to make it easier. But you can always go and download that handbook, which has all the information that we have presented on these 3 videos. So we hope that we have been helpful with these videos. And remember, you are not alone. There are several family resources, and of course, your regional centers that are always there to help you. And there is the ATP, the Adult Transition Programs. If your loved one is still of age to be part of the district, you can also have the free legal services like legal aid, or there's also community organizations, several. And there's us, Navigating Change, as part of San Diego State University. There is an exceptional family resource center that are very knowledgeable about that too. So just be sure that you are not alone. We understand from parent to parent. And please, maybe you're the grandmother, maybe you're an aunt or just a loved one who has decided to take care of this vulnerable person. And we appreciate that. And we wish you the best on this endeavor. And please remember that supporting a loved one through the transition to adulthood is an act of love. Conservatorship is a tool to protect, guide, and endure their well-being. So we hope that we have helped you again. And one more time, please, thank you for taking care of that wonderful human being that you have under your care. Thank you. And if you have any questions, you can reach to us and we can guide your question to whichever resource we find suitable for you. Thank you for listening.